This is Barry Zalma on Insurance. I'm an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness and author and producer of these videos. Today I'd like to talk about the resolution of conflicts involving other insurance clauses in dealing with insurance claims and insurance policies. Where two or more insurance policies may be called upon to apply to a loss, conflicts may arise involving the three basic types of other insurance clauses. Since every state seems to apply other insurance clauses differently, regardless of type, it is the obligation of every claims person faced with conflicting other insurance clauses to seek the advice and counsel of a local insurance coverage lawyer who can explain that the major categories of conflict arise when 1. There is no other insurance clause in either of two policies. 2. There is another insurance clause in one primary policy, but not in the other primary policy. 3. There are similar other insurance clauses in both primary policies, or 4. There are dissimilar other insurance clauses in both policies. Coverage counsel can then provide the claims person with advice about how to fairly and in accordance with the law of the jurisdiction apply the multiple other insurance clauses in accordance with the obligation to deal fairly and in good faith with the insured. First, consider where there is no other insurance clause. When there is no other insurance clause in either of two primary policies, the majority rule holds that any loss should be apportioned among the co-insurers in the proportion that the indemnity limit of each policy bears to the aggregate limits of all available insurance up to their respective limits of liability. The courts with no clause to direct them simply create an apportionment. For example, if insurer A has a policy with a $100,000 limit and insurer B has a policy with a $300,000 limit, insurer A will pay 1/4 of any indemnity or defense clauses, and insurer B will pay 3/4 because the total amount of coverage available is $400,000. Under the law of California, for example, Hartford's escape clause must be invalidated and Lexington's contribution by limits provision controlled. The pro rata clause requires each insurer to pay the same proportion of the loss that its liability limit bears to the entire amount of available insurance. Both the Hartford and Lexington policies had liability limits of $1 million. Therefore, Hartford should reimburse Lexington 1/2 of the settlement amount and attorney's fees. This was found by the Ninth Circuit in Lexington Insurance Company v. Hartford, a 1993 decision. The fairest and easiest method to share obligations to the same insured is a simple mathematical proration based on policy limits. This method will almost always be applied if there is no other insurance clause or if the other insurance clause in the policy is declared invalid or unenforceable. When there is an other insurance clause in only one policy, the primary policy but not the other primary policy, courts generally will give effect to the other insurance provision, if it is not contrary to statute or public policy. Because the court, when dealing with insurance contract interpretation, is acting as a court of equity and must do what is fair to all parties. The court concludes, therefore, that it is in the best interest of both parties, even if one has no other insurance clause or an unenforceable other insurance clause, to prorate the liability between various insurers. public policy does not prohibit enforcement of an other insurance provision when there is other full legal coverage. The courts make an effort to carry out the intent of the insurers. It has been held that where two policies contain the same language with respect to definitions of insured and the definitions of primary and excess insurer, both insurance companies must contribute equally. Then there's the problem when there are similar other insurance clauses in two primary policies. Traditionally, when two policies contain pro rata other insurance clauses, each insurer is liable for the proportional to loss which the amount of its policy bears to the total amount of collectible and valid insurance. When both policies contain a pro rata clause, each carrier is primarily liable with respect to the vehicle described in the policy, and protection should be afforded in proportion to the maximum coverage afforded by each of the policies. When there are two excess clauses, most courts hold that the excess clauses operate to cancel each other out, and the policies of both insurers must be considered primary insurance. The courts then apply the majority rule that where neither policy contains an other insurance clause, each insurer must pay a pro rata share of any settlement, judgment, or expenses, because it would be unfair to one or the other to allow one to escape liability. When there's an escape clause versus an escape clause, besides excess clauses, some insurance companies have inserted escape clauses into their policies. Instead of making Company A's coverage excess to any other available insurance, an escape clause in Company A's policy would state that it provides no coverage if there is other available insurance to cover the claim. Not surprisingly, when two policies that would otherwise provide coverage for a claim are both found to have an escape clause, the doctrine of repugnancy is once again brought into play. The result is that the two escape clauses are ignored and both companies are held to provide primary coverage of the claim, because having two policies with escape clauses gives you nothing if they're applied as written. When there are dissimilar other insurance clauses in two primary policies, the majority of courts attempt to reconcile the dissimilar other insurance clauses, such as pro rata versus excess, excess versus escape, escape versus pro rata, by giving effect to the intent of the parties as stated in the policy wording. Through an examination of the language of the clauses, the courts try to determine, if at all possible, which insurer intended to be primarily liable and which only intended to be liable on an excess basis. Courts applying the majority rule to cases where other insurance clauses conflict analyze the language of the policies in the light of the circumstances of each contracting party to determine the intention of each contract within the design of a consistent overall insuring scheme. Now, when there's a pro rata clause versus an excess clause, courts adopting the majority view have generally reconciled the pro rata clause and the excess clause by interpreting the policy containing the excess clause as providing secondary coverage. For example, one court stated, "We see no need, in order to decide this case, to attempt a rationalization of no liability and excess liability clauses in insurance policies generally. It is enough to say that Northwestern National Insurance Company could properly limit its liability for negligence acts, errors, and omissions which occurred before the effective date of its policy so as to provide coverage to apply only as excess insurance over any other valid and collectible insurance, and which shall then apply only in the amount by which the applicable limit of liability of its policy exceeds the sum of the applicable limits of liability of all such other insurance. We are persuaded that the equities of the two insurers are not the same, and that the trial judge properly concluded that the carrier, the defendant Michigan Millers, whose policy was in effect when the error and omission and the loss of its customer occurred, should bear the entire loss without contribution by the other insurer, Northwestern. This is P.L. Cantor Agency versus Continental Casualty, a 1976 decision of the Sixth Circuit Court of Appeal. Then consider a pro rata clause versus an escape clause. When conflicts between the application of a pro rata and escape other insurance clauses arise, courts generally hold that the policy which contains the pro rata provision is primarily liable. The reason underlying this majority view is that the policy containing the escape clause does not provide other valid and collectible insurance within the terms of the policy containing the pro rata provision, whereas the pro rata clause policy is other insurance that gives effect to the escape clause. In the leading case, the lessee of a truck which was involved in an accident was covered as a named insured under a Hartford Accident and Indemnity Company policy. The owner of the truck was a named insured under a policy issued by American Employers Insurance Company. The American Employers policy also covered the lessee as an additional insured. The American Employers policy contained an escape clause. The Hartford policy contained a pro rata clause. The court compared the language of the two clauses and held that American Employers policy containing the escape clause did not constitute other valid and collectible insurance within the meaning of the Hartford policy's pro rata clause. The court enforced the escape clause and refused to require American employers to contribute to the costs incurred in connection with the tort action which arose from the accident. This is a case called American Home versus Hartford, a 1980 decision of the New York State courts. When there is an escape clause versus an excess clause, the majority of courts hold that the policy containing the escape clause is primarily liable for the loss, and the policy containing the excess clause is excess insurance. The reason for this rule is that the policy constituting excess insurance only does not provide other collectible coverage so far as the no liability clause of the other policy is concerned. In Michigan Alkali Company versus Bankers Indemnity, a 1939 decision of the Second Circuit Court of Appeal, the court interpreted New York law to be consistent with the majority approach. The insured was covered by two policies. One policy contained an escape clause, and the other contained an excess clause. The court compared the language of the other insurance clauses and concluded that the policy containing the excess clause was not valid and collectible insurance within the meaning of the escape clause, since the excess clause policy by its terms was excess to other insurance. The court held that the insurer which issued the escape clause policy was the primary insurer, and that reasoning from the Michigan Alkali has been followed by many other courts. In Indiana, for example, when insurance coverage provisions are mutually repugnant, each insurer is held liable for a prorated amount of the resultant damage not to exceed its policy limits. Of course, no approach is universal, as has been obvious from the discussion. There is also a minority approach where a small group of jurisdictions take the position that all other insurance clauses, regardless of their nature, are mutually repugnant. These courts find it impossible to give effect to conflicting other insurance clauses, refuse to apply either one or both of the contracts, and refuse to adopt any of the clauses, claiming that each cancels the other out. The majority approach to resolving conflicting other insurance clauses began as early as 1959 in a case called Weston versus Oregon Auto Insurance, an Oregon Supreme Court decision. In Weston, the court was confronted with two co-insuring primary policies. One contained an excess clause and the other a pro rata clause. The court reviewed judicial attempts to reconcile such conflicting clauses and concluded that any attempt to give effect to the other insurance provisions of one policy while rejecting it in another is like pursuing a will-o'-the-wisp. While the rule has been criticized for riding roughshod over the parties' rights to contract, it has also attracted a fair number of followers. Despite a long-standing and widespread dissatisfaction with the policy-by-policy approach to the problem of concurrent coverages, it is a problem that has been left to the courts and, not surprisingly, absent industry or legislative direction, has defied general solution. This video was adopted from my book, Zelma on Insurance Claims Part 102, Second Edition, which is available from Amazon.com as both a Kindle book and a paperback, and is part of a 10-volume work called Zelma on Insurance Claims. If you found this video to be interesting or of use to your colleagues, please pass it on. It's free. And please subscribe and follow me on my YouTube channel and my Rumble channel and my blog so that you can learn of new videos and new blog postings. Thank you for your attention.